Hi and welcome to Legal and Ethical Issue. And this time we're studying lecture 5, which is very, very interesting questions. And I'm going to also cover the legal protection because I want you to know what the law is saying, and I also want you to know what ethics are saying and our value in our society. Now remember, we are a society of individuals. We are achievers. We become who we are because of what we are achieving, not because of where we were born, like in other society. And if you want to have an example, for example, even religion. As a Catholic, you're born into the Catholic religion. As a Protestant instead, even if your parents are Protestant, that you have to someday decide if you believe that Jesus Christ died for your sin. That's big difference right then and there. So this chapter will be very interesting, or this lecture really I should say, is how can you have a duty of loyalty, loyal to your employer, and at the same time whistleblowing. How can you do that? How can you do it? And what the law is saying is who is in a better position to know what's going on in your employment? Who is in a better position to know when your employer is doing something illegal? Who is in a better position to know when your employer is doing something that is harming to society at large? And therefore, yes, you have to be loyal to employer. He's the one that is giving you your paycheck. But what about if he's asking you to do something that it's illegal? Or if he's asking you to do something that is unethical according to your values? Are you going to be protected under that situation? And the interesting part is that there's a psychological study, and that is that we have a tendency, the Milgram study, which was very, very interesting, and where there were some people that they were picked to give a test to some other people. Little did they know that the people that were picked to give the test were the subject of the test. And they were supposed to give electrical shock to anybody that misspelled the words. And I have to tell you that in this study, there was only 2 people that refused to give the electrical shock when people incorrectly spelled the words. And the people on purpose start to spell the word incorrectly to see how far the people were willing to give electrical, to the point that some of them were hurt. And most of us will obey. I get paid to do what I'm told to do. You know, I don't get paid to ask questions. I just do what I'm told, and that's usually our attitude. Mind your own business. You know, don't ask questions. Just do what you're told. And many employers like those kind of employees. Well, the law is saying something else, and this is why this is going to be very interesting. And before I go into the loyalty and the whistleblowing, I want you to know our employment situation. Right then and there, our employment situation is a contractual relationship. As soon as I say contractual relationship, that means the employer has a duty. Has a duty to provide safety, has a duty to compensate you, and of course you have a duty to be loyal, to do your work, to be accountable, whatever it is. These are the things. It's a contractual relationship. So you know that the employer right away kicks in as a legal duty. And I'm giving some of the historical roots where from the feudal to non-feudal system, we have the master and servants. Well, not in the United States. The United States, we have equal bargaining. Very, very interesting. We have equal bargaining. If ever you get a chance to study labor law, for example, it was very, very interesting to find out how the union were born. And the National Labor Relations Act was the first act that did that. And many times in our Industrial Revolution time, 1920, 1930, we had a lot of immigrants that didn't even speak English. And when they came over then, they were so happy to find a work. They did not know that there was a contractual relationship. They did not know that we have any equal bargaining. They did not know that we can negotiate our paycheck. They did not know any of this stuff. They were just happy that we had, you know, that they had work so that they can send some money back home or someday have their family coming up here. And apparently, when you're dealing with your employer, there's a one-on-one situation. There's not such a thing as boilerplate. There's not such a thing as everybody gets paid the same amount of money. It depends on what you're negotiating. And the first case that happened in court that was very interesting, when the employer decided to pay, for example, $1 an hour on an immigrant that did not speak English, Then came another immigrant, and the other immigrant was able to negotiate a little bit, and he says, please, can you give me $1.50 because I have 10 kids, you know. So he says, sure, I'll give you $1.50. And then it just happened that the two immigrants were from the same country, and one of them was getting paid for the same job, $1 per hour, and the other one $1.50. Well, the one at $1.50 ethically felt that, you know, this is not fair because we're doing the same thing. So let's go together and see the employer and see if I can help him to get you the $1.50 like I do. And of course, when the two employees went to speak to the employer, the first case they were arrested for conspiracy. It was a criminal case. So next thing you know, the court realized that really in unemployment, we don't have equal bargaining. We really don't have it. Really, the employer has the upper hand over us. So at that situation then, instead of having 600 employees come into your office because they want to treat it equal, they decided to have employee has the opportunity by statute to appoint a person that he represent you, the employees, and then he negotiates an agreement with the employer, and that's what gave birth to the union. Very, very interesting. So, freedom of individual contract. Of course, there's exception. Because in the United States, we have such a thing as employment at will. That means we have a freedom to contract and we have a freedom to terminate the contract. And we don't have to give any justification. We don't have to give any reason. That's it, out. So here is the exception, because sometimes people will terminate you because they don't like you. And that is what? Wrongful discharge. And so that's not fair. You know, networking, or they hire somebody because she's more gorgeous than you are, or maybe it's like me, for example. I have the freedom to have a law firm, and I like Tom Selleck, so why not hire everybody that looks like Tom Selleck? And I want Tom Selleck that look alike to sit on my lap. That's my freedom. But is that fair? What about a person that, you know, that does not look like Tom Selleck, but he might be a better typist or a better computer person or a better paralegal, but he doesn't like Tom Selleck. So this is where the court comes in, because everybody has to have equal opportunity. Everybody has to be treated equal. It's not up to me to judge, oh, it doesn't look like he can do it. No, that is not correct. That is not legal. So here is the exception. Judicial intervention, that is that you go to court and the court says, yes, you're right, it was wrongful discharge. The person should not terminate you, because they should be only terminate you because your performance at work is not up to. Not because you're too tall, not because you're black, not because you're female, not because you're different religion from a Protestant, not because your nationality is Polish and I don't like Polish people or Italian people or whatever it is. And of course, legislative intervention is when the Congress writes a statute that says you cannot do that. And of course, the one statute that is very important is the Civil Rights Act of 1964. Because the Constitution used to help employees that works for what? Employment of the government, public employment. The Constitution kicks in. So public employment, because of the Constitution, could not discriminate. But any private corporation, legally, they could discriminate all they want to. Ethically, not necessarily. But legally, yes. And again, ethics cannot be enforced, but the law can be enforced. So what happened? By 1964, we start having our Civil Rights Act that is telling us, corporation, even if you're private, you're not allowed to discriminate against. So that's legislative intervention. Wrongful discharge. When is it wrongful discharge that the court will intervene, or that you will have the keys to get into the court to be heard? When your employer is asking you to do something that violates public policy. What is public policy? Again, it's what? It's a group of people out there that believes there's a certain expectation of behavior that we should be behaving, our conduct, our relationship, business and the people, or between the people. For the good of society, public policy is we should not behave like that. For the good of society, we should not be harming each other. For the good of society, and remember, we still got the Constitution that tells us, hey, we are supposed to be treated equal. And of course, the whistleblower statute, which is a new statute. Well, I call it new because it's 1986, so it's much later. It's new in a sense that it's not like 1950, 1960. The whistleblower statute, both federal and state, and this is very interesting because first of all, you have the federal government says that nationally, that means every state has to have this law or comply with this law. And then every state makes their own law. And if every state or all the states makes their own law, their laws of the state has to be more stringent, has to be more protective of their taxpayer. So, for example, the Civil Rights Act of 1964, it's a federal law. In New Jersey, we have the same act, we call it LED, and it's much more protective of the individual because New Jersey State has police power, and they're much more protective of their taxpayer than maybe Pennsylvania. And Pennsylvania, of course, thinks that the kind of people that likes to move to Pennsylvania, they're going to have the laws that reflect the people that moves in Pennsylvania. And Montana would have different kind of people, and California has different kind of people. The same thing, almost like the motor vehicle division of driving. I mean, you drive the same way in New York and you drive the same way in New Jersey. However, if you move from New York to New Jersey, you have to take a written test. Why? Because we believe that we have more protection over here. We have different situations. We're not like in New York. We have more space, so you can park more further away from the stop sign. Where in New York, you can park closer to the stop sign. Little difference like that because we're a different state in many, many ways. And another way that the court will interfere is that sometimes the employer would make life so miserable for you at work that you quit. And that's what they call a constructive discharge. It's almost like the employer made a construction to discharge you because you had to quit. It was so miserable there. Legislative intervention, again, is Congress. And of course, the first act was the National Labor Relations Act, which prohibited discharge for reasons such as concert activities. And this was very interesting because the union could discriminate their head off. If they didn't want Polish people to come in the union, they didn't have to. However, the only thing that this act was saying is make sure that the employer do not discriminate because employer did not want to hire people that were union members. And if that was the case, then the employer would be in a responsibility. But the union could discriminate the head off. Then we have OSHA, and everybody knows about OSHA. That's a federal state again, federal law, I should say federal state. Occupational safety and health, protesting unsafe working condition. This is national, you know. We have also our own state laws, but OSHA is pretty famous for corporation. They want to make sure that not only does the contract that you work with your employer, the terms of payment and employees' benefit and working hours and minimum wages and so on, but also the condition, the terms and condition of your employment has to be safe. This is why later on we're going to go into hostile environment, very interesting. The Fair Labor Standards Act, again, minimum wages, very interesting because there has to be a minimum wage, and sometimes employer, especially if they know that you are illegally here, they will say, hey, I'll keep my mouth shut and I will not have you deported, but then I'll pay you only $3 an hour instead of $5.25. Well, there has been cases where the illegal immigrant went to court against the employer because according to the law, he should be paying minimum wages. So this was very interesting because it gave birth in 1986 to immigration. Now you have to have a copy of your driver license, or registration of your car, you have to have a social security card, you have to have 2 out of 3 that you are legally here in this country. And because of these cases where illegal immigrant took the employer to court and the employer were liable, that means they had to pay back the illegal immigrant all the money they owned. The employer then starts saying, hey, I'm not going to hire any more people with an accent because the employer cannot ask you questions that are not related to your performance. So whether you are legally here or illegally here does not mean that you cannot, do software, or you cannot clean or vacuum clean a floor or clean up, empty the garbage pail. So he cannot ask you whether you're legally or illegally. So there was a time then that the employers are saying, we're not going to hire anybody that has an accent. So by the time I graduated from law school in 1989, all at once I had to prove that I was legally here, and I had to show my identification, driver license. And it was very interesting. And what the court is saying is the employer has to make sure that you are legally here. Even if those papers are illegal, I have a fake social security or I have a fake registration, it doesn't matter. The employer then will not be liable for me to to take him to court because he did not pay me the minimum wages. So it's very, very interesting that way. The Civil Rights Act, which I already mentioned, remember, it's prohibiting discharge based on race, color, religion. Sex does not mean what position. It means gender, male and female, and national origin. Equal pay, it came almost out at the same time, and that is because many times when, this is again in 1966, 1967, women start coming into the business world, and many times they would ask men to work at night and not the woman. But by working at night, you were getting more money. So this is where we had the equal pay, because the woman wanted to have the same opportunity to work at night so that they can also make more money. Very interesting case. Then you have the age discrimination, and of course this is going to be interesting to you. If you are over 40, you're protected. So if you are discharged or you are terminated and you are 42, 43, and they hire somebody under 40, we call it prima facie case. On the face, it looks like it could be that you're terminated because of age, and therefore you can have the keys to get into the court to say, Your Honor, help me. I was terminated because of age and not because of non-performance. And of course, the company is going to say, oh, that's baloney, I never did that. Very interesting that way. Then you have the American with Disability, which is a new law in 1990, and that is again disabled people. Many, many disabled people were in SSI, Supplement Social Security Income. And as a society, in 1990, 95, all this time we were complaining that people should be able to work and not receive a check from the Social Security or SSI. They were young people. And what the government did then would encourage, by having this act, is encouraging corporations to hire people that are disabled as long as they can perform the work, to the point that the employer has to make reasonable accommodation so that the disabled people can work, can get an education, can become independent instead of depending on taxpayer money. That was one way to solve the problem that they did. The Family Medical Leave of Act 1993 was the same thing, because many times a woman then, by having a baby, she would have to stop working. There are cases where if you were pregnant, you could not work because they didn't want anybody, to explain to the children, we don't talk about sex. So how come the lady got fat, Well, she's pregnant. Well, how come she got pregnant? Oh, well, the stork put the baby there, or something like that. We just did not, one conversation, we don't talk about sex to our children. Where other country, it's a natural thing. I mean, children sleep in the same room of the parents, the bedroom. So it's something that it's an accepted behavior. Here, definitely, you put your children in a separate room as soon as they are, 6 months or a year old. You don't put them sleep in the same room with the adults. So you see the difference of value. You have the Vocational Rehabilitation Act, which is again only for people that work for the government. This is why we have the American with Disability, which is working also in a private company. And then you have affirmative action, which is a remedy. This is why by 1989 the court says, hey, no more affirmative action. Now we use the word diversity, encouraging companies to hire people with a diverse background, diverse culture, diverse religion, from the prevailing culture, which is more Protestant and white. Affirmative action was a remedy for past discrimination. When we go into later on the chapters, you're going to learn more about it. And then, of course, you have the Employee Retirement Income Security Act, which is make it very interesting, because the whole point of the Security Act, Social Security, was for people that did not have any pension. Instead, today, people first gets the Social Security Act, and then the pension is something extra. Very, very interesting. Employee welfare program, Social Security, workers' compensation, another one, very interesting. We have a whole lecture on that chapter. It will be great. Then you have the contracts. This is just the rules and regulation to protect people, to make sure we have equal opportunity. We have the collective bargaining agreement. And of course, you cannot terminate a person unless there's a just cause. And we are working on a uniform code, but New Jersey did not sign it yet because we don't agree with the definition of what is just cause. Because in New Jersey, just cause is not the same definition that is in Pennsylvania or in New York. So it's very interesting. The employment handbook, that is an implied contract, in fact. I enjoyed that very much. Many handbooks says, well, this is not a contract, but then they tell you what kinds of terms and conditions. You have to do this, you have to do this. Yes, it is in contract. That handbook is a contract. The covenant to good faith and fair dealings, again, it's an implied contract again. If I'm going to hire you and you're going to be working there 10 years, 12 years, 13 years, there's a good faith that they like the way you work. And so here you are, 55 years old, and I had cases that I had to deal with that. You know, working 21 years with a company, and next thing you know, they're terminating because they changed boss. And it was a family, not really, yeah, I guess the owner was a family, but next thing you know, his son took over because he retired, and his son decided to have friends coming over, and they discharged this guy that was 55 years old with nothing. Nothing. You know, he was Polish, he did not know he's entitled to some kind of agreement. And after being covenant of good faith, he's been working for so many years, and then could it possibly be that they terminate him because he's Polish? Yes. Could it possibly be that they terminate him because of the age, because he hired all his friends that were 35, 29, something? Yes, it is. That's what it looks like. So, and then workplace torts. Again, torts is what? Between people. So between employees, what happens here? Invasion of privacy. You have a right on the Constitution that you should be hired only because of your performance, and not find out if you have AIDS, or if you have asthma, or if you're going through a divorce. And this is what causes a lot of problem, because today more and more companies are allowed to look into your credit report. They are allowed to ask you a propensity test, or they give you a psychological test. And their reason is because more and more of us are working as a team because of our expertise area. Not everybody can know everything because of all the information we have there. And then how you work as a team, you know. And they ask you a question, for example, you know, do you kick a dog? And of course, if you kick a dog, they might not hire you. And you might say, no, I don't like to kick a dog. And then later on, they have another question to another way. Present the same situation that maybe you said yes, and then the inconsistency, well, they want to have somebody that is consistent, and you might not get a job and you don't know why. But they give propensity tests because more and more now we hire, like for example, athletes, and they have big millions of dollars contract, football or baseball, and after a couple of months that they play the games, they get into a crime and they're going to be arrested and put in jail. And the baseball company or the football company or the football industry or the sport industry has to pay the contract even if the person is in jail. So more and more you see that propensity tests are allowed to come in even if they don't relate with the performance or the qualification of the employment. Defamation, very interesting. Defamation, very easy. You know, human resources have all kinds of records. And there's always that person that in human resources might say, hey, did you hear such and such a person? You know, he's taking this prescription. And this prescription, as far as I know, is only if you have AIDS. And next thing you know, rumors gets around. And this particular case that comes in my mind, the poor guy goes to the cafeteria and have lunch. And what does he find? Nobody wants to sit next to him. And the next thing you know, there was defamation. That means you say something about someone else that is hurting a third party. And sometimes that information is just by giving it to the secretary to type a letter. And that is enough to cause defamation. And of course, intentional infliction of emotional distress. The same person that is accusing the company for defamation also can accuse the company for intentional infliction of emotional, because that's an emotional distress. All at once, nobody's sitting next to you. Or you're getting demoted because they want to move you down the basement so that your disease doesn't get spread. Or you might, you know, so next thing you know, you quit because you cannot work in a situation. And these are all protection to make sure that the employer treats you equally. Because basically the court officially knows that we don't have equal bargaining. The court knows that we discriminate or we prejudice, let's put it this way. And well, they cannot challenge what we're thinking, but they want to make sure that whatever we're thinking, we don't make it into action. And if we do make it into action, then we'll be liable because it's hurting somebody. Wrongful discharge. This is where most of the cases are dealing with, I was wrongfully discharged all the time. Nobody ever in the mind that I hear I was terminated came to my office and said, I was not wrongful discharged. I was a lazy bump. I mean, you know, each one of us don't believe that, we believe that we don't get paid enough, and that downsizing, we are wrongfully discharged, it's not my fault. I call it the blame game. Anyhow, it's a very, very complex concept. And why? Because you have to be loyal to your employer. That's your duty. You have to be loyal or have a duty to your personal professional code, and also to the society at large. For example, you know, as an attorney, I have to keep all information confidential. Attorney and client privilege. And the question that I always get asked, how can you defend someone that you know killed? That's my attorney and client privilege. So if the client tells me, listen, I killed somebody and I want you to defend me, I have to defend him because he has a right under the Constitution to representation. Now, if I'm a public defender, I have to. If I'm a private criminal case, you know, I might go to my boss or the partners and says, you know, I really don't want to take this case. It's against my value. I can't take it. And he gives it to another attorney, or he might send it to another law firm. But I have to, because the person is innocent until proven guilty. And just because he told me that he killed somebody does not mean he did. Because there might be a lot of circumstantial evidence that he thinks he killed, because maybe by, you know, tripping this person, the person died, and maybe this person died because of a heart attack and not to do with my tripping. Or the knife, you know, I stabbed somebody, but the person died, but not because of the knife as much as because of already a heart attack. Or this is why it's very, very important, the evidence to be not tainted. And then the public at large. You know, what kind of society are we? We don't trust each other, and we value trust in this country. Not in other country. In the United States, we value trust. Shake hands is a contract, it's a promise. And we're going to discuss these legal and ethical perspective on the board, because I'm sure you're going to have questions, and I welcome questions before we go into the next part. Thank you.